Donna Adelson's attorney files what she calls an emergency motion to enjoin the jail for an independent psychological evaluation or release to house arrest. So, best case scenario, Donna's attorney is asking that the judge should order that Donna be sent home on house arrest. That's best case scenario. The chances of that happening are probably zero. But there's also alternative relief that she's asking for in case the judge does not want to grant her house arrest. She's also asking alternatively for an independent psychological evaluation. What's the point of that? Well, we'll get into that in just 1 minute. Now, when you file a motion like this as an attorney, as we spoke about in the past, you have three main jobs to do when you're filing this type of motion. Number one, you have to lay out the factual allegations as you know them. That's number one. Number two is you have to attach support to the factual allegations. Why should the judge, why should the court believe what you're saying happened? That's number two. And now if it's undisputed facts, you can say this is undisputed. Both sides agree about these facts. But if it's disputed, then you've got to, or you think that it could be disputed, then you've got to attach some support to your factual allegations. And number three, what you have to do is you have to analyze it under the law. Part of what your job as a lawyer is not just to tell the court what happened, say that it's not fair, and then ask the judge to help you out. The judge is not just going to help you out because he feels bad for you. What you have to do as a lawyer is you have to give the court some legal basis for the relief that you're requesting. You want the judge to let her go free? Well, what's the basis for that? You want the judge to order this this independent psychological evaluation? Well, what's the basis for that? Give the judge a basis in the law for what you're doing. So those are the three main jobs. You got to recite the factual allegations. You've got to support. You've got to attach some support that the factual allegations that you're saying happened actually did happen. And number three is you've got to present the arguments under the law. Give the legal basis for it. Now, they did two things in this very well, which we're going to discuss. They did cite the factual allegations, and they also made reference and made arguments for the basis under the law to grant to grant the relief that they're requesting. But one thing that is glaringly missing is that there's no attachments to this motion. There's no support. Where is any sort of documentation supporting this type of motion? Now you can say, well, it's very hard to get some documentation. This is called, after all, it's called an emergency motion. But what about an affidavit? Why couldn't they go get an affidavit from Donna? They should have got an affidavit. Well, part of the argument that they make in this motion is that they didn't say this, but this is what you can learn from it, is that they say that they were not able even to have any conversations with Donna once she already arrived at Leon County Jail. Once she arrived at Leon County Jail, they did not have any interactions with her at all. Now, they didn't say in the motion, that is why we didn't get an affidavit. I think that it would have been prudent of them to say, Judge, we would have loved to attach an affidavit from Donna, but we couldn't do that because we were not able to get any access to her. That, I think, would have helped her position. And number two, the question is, well, if you had no conversations at all, you had no interactions at all with Donna, well, then how do you know all this stuff? You're going to say some pretty crazy stuff in here. How do you know it even happened? So the only option is the way that this is the defense, this is their attorney, this is Donna's attorney. From the face of the motion, the only way possible that anybody outside the jail would have found out about any of this that's going on is in a 5-minute conversation that Donna had with her husband. That's what they agree. That's what they say in the motion. This is their words. This is not me making this up. They say in the 15 days that Donna has been at Leon County Jail, she has only been permitted to call her husband once on November 28th, 2023. By the way, this was filed December 5th, 2023. Why didn't they file it earlier? Okay, question to be asked. If this is when they found all this information. Well, maybe you'll say that the husband didn't speak right away to the attorneys, but I think that would be crazy for the husband not to, because if this type of stuff is going on, then the first thing that you should do is call her attorney. But anyway, let's move on. So in the 15 days that Donna has been at Leon County Jail, she has only been permitted to call her husband once on November 28th, 2023 for approximately 5 minutes. So she was able to talk to her husband in 5 minutes, and in those 5 minutes, this is the reasonable inference. This is the inference that you have to make from this motion. The attorneys never spoke to Donna. The only person who spoke to Donna was her family member, said her husband. Her husband spoke to Donna for 5 minutes, and in that 5 minutes, she was able to tell him everything that you're about to hear in this motion. Pretty fantastic. I mean, that's what they're suggesting. Now, they didn't say this. I think it would have been very helpful for the attorney for Donna to say, we couldn't get her affidavit. We tried. I tried to speak to the jail. And don't just say you tried to speak to the jail as an attorney. I tried to speak to the jail, but they didn't let me. I tried to speak to my attorney, but I tried to speak to Donna, but the jail didn't let me. The prison didn't let me. Don't just say that. Say what you did. Say what steps you took in order to try to reach Donna. I called on this date. I spoke to this person at the jail. I called on this date. I had my assistant call on this date. I lay out exactly what you did, what steps you took. Don't just say, I tried and I couldn't get through to her. You know, it's much more concrete and it's much more believable to the judge if you're able to say directly and explicitly exactly the steps that you took. That was missing from this motion. I think it would have helped her. I think would have helped this motion if they would have laid out specifically what steps they took. But again, it's pretty fantastic that the only way that they got this information is from a 5-minute phone call. This is according to what they said. Donna had with her husband. That would be pretty interesting. I'd like to hear that phone call. You know, all these phone calls are recorded. I'd like to hear how fast she's able to tell her husband about everything that's been going on. Okay, so what are the factual allegations that this motion is dependent on? Well, everybody knows that Donna Adelson was arrested on November 13th, 2023. Now, you've got to smile. You've got to appreciate how her attorney is representing Donna Adelson in this motion. Now, you see some lawyering going on. This is what they call lawyering. Now, if I would ask any of my intelligent viewers, I'd ask them, how would you describe Donna Adelson? Describe her, just very simply, how would you describe her? So you may say that she's a 73-year-old woman, right? She's a 73-year-old woman. I think that's a fair representation of who she is. Listen to how her attorney talks about Donna Adelson. Donna Adelson, a 73-year-old grandmother. 73-year-old grandmother. Is that how you would describe Donna Adelson? A 73-year-old grandmother? I mean, she is a grandmother. But that's not how you describe her. You say, Donna Adelson is a 73-year-old woman. But the reason why they're doing this is lawyering. The reason why they're doing it is because they're right away trying to get sympathy. They're trying to get the judge on their side. This is a 73-year-old grandma. She's a grandma sitting in prison. Come on, have some mercy on her. That's what they're doing here. And that's what they're trying to sneak in. So Donna Adelson, a 73-year-old grandmother, was arrested in Miami, Florida on November 13th, 2023, after her son, Charles Adelson, was convicted of murdering Dan Markel in an alleged murder for hire plot. The evidence, and this is what they say, the evidence against Donna is circumstantial at best. So here again, they're saying, look, they don't really have any direct evidence that Donna was involved in this anyway. So first of all, you got this poor old grandmother who's sitting there, and they don't really even have strong evidence. It's circumstantial at best. Now, this is something that attorneys like to play both sides with this. They say, the evidence is only when it doesn't benefit them. When it doesn't benefit them, they say, the evidence is only circumstantial anyway. But on the other hand, there's an explicit jury instruction which says that circumstantial evidence is also evidence that the jury can consider, and the judge should be able to consider also. So circumstantial evidence is not like, it's just circumstantial evidence. You know what circumstantial evidence is? Let me give you an example. You see somebody walk into a room. He closes the door. You hear a gunshot. He walks out of the room, and he has a gun that has smoke coming out of it. And he puts that gun back in his holster, and he leaves the room. You go into that room, and there's a person dead in that room. That is circumstantial evidence that that person committed the crime. There's no direct evidence. Now, how strong is that circumstantial evidence? Extremely strong, right? Can he get a conviction out of that? Of course he could. But it's still circumstantial. So it's circumstantial evidence can be very, very strong evidence. And certainly in this case, there's some pretty strong evidence against Donna, even if it technically can fall under the category of circumstantial evidence. But since this is Donna's attorney talking, they're trying to paint it in the other way. So they're saying, number one, she's a grandmother. Number two, the evidence against her is only circumstantial at best. It's not really such great evidence. It's pretty good. It's pretty good evidence. But anyway, so now let's continue. Then they say like this. So she was arrested November 13th, 2023. She was taken to TGK jail. In TGK jail, she was placed in a psychiatric unit. Now, let's stop for a second again and ask my intelligent viewers and subscribers. And if you haven't subscribed yet, please subscribe. Why was Donna placed in a psychiatric unit? Can anybody think of any reason why Donna would be placed in a psychiatric unit? Can anybody think of a reason? Well, let me tell you the reason that Donna's attorney says that she was placed in a psychiatric unit. Donna was placed in a psychiatric unit because of the charges against her. Now let me ask you, is that the reason why she was placed in a psychiatric unit? Does that mean that anyone who's charged with first-degree murder, solicitation to commit murder, conspiracy to commit murder, every single person is put in the psychiatric unit? Really? Is that the suggestion that her attorney is making? Or is the reason, perhaps, that the reason that Donna is being placed in a psychiatric unit is because she actually told Charlie on the phone in her jail calls that she's contemplating committing suicide? Maybe that could be a reason why she was placed in a psychiatric unit? Would anybody think that? But again, this is Donna's attorney, so Donna's attorney is trying to make it look like, yeah, this has nothing to do with her suggestion that she may commit suicide. This is because the charges against her. Okay, anyway, let's continue. So she was placed in an isolation cell with a small sink, mattress on the floor, blanket, and a toilet. Of course, it's not going to be a 5-star hotel in there when you're in a psychiatric unit. Donna did not have access to any clothes, cups, silverware, books, blankets, or toiletries, and was only permitted to shower once. Well, yeah, again, it's very limited when you're in a psychiatric unit because anything that they give you, you can technically try to use to kill yourself. So, okay, we feel bad for you, but, at the end of the day, we may feel bad for you, but at the end of the day, you're in the psychiatric unit for a reason. Now, she had 2 psychiatric evaluations while she was at TGK. Within 96 hours of her arrest, she was cleared and she was placed in the general population. So 96 hours after the time that she arrived in TGK, she had 2 psychiatric evaluations and they determined that she is not a suicide risk, apparently, and therefore she was allowed to be with the general population. Okay, then what happens? Well, what happens next is that she's transferred to Leon County Jail. November 20th, 2023, she's transported to Leon County Jail. Now, during the ride, she says that she wasn't given any water, she wasn't allowed a bathroom break, and 4 or 5 hours into the trip, the officers checked on her and she was shaking, dehydrated, unable to stand or move, and they had to call paramedics. Okay, so now that happens. Now she gets to Leon County Jail. She's first put in the infirmary under direct observation, and then she's placed again in a small solitary unit. And this is where their argument's coming. Their argument's coming is, hold on a minute. She was just cleared after 96 hours of being in TGK, and now she's in Leon County Jail, and they're putting her back in solitary unit. What are they doing? Why are they doing this? That's not fair. She requested a book or Bible. It hasn't been given anything, and she's been forced to eat her food with her hands. And then, while she's there, she starts being questioned by one of the mental health officials, and Donna doesn't want to be forthcoming with her. So it sounds like Donna's kind of not giving them information. So it almost sounds like the mental health professionals trying to ask her a bunch of questions to see whether she's still suicidal, and Donna does not seem to be forthcoming. But they don't go into detail. Her attorney does not go into detail exactly how this conversation happened. It could be in those 5 minutes that Donna spoke to her husband, she was not able to go into detail about this. But it's pretty amazing that all this information was learned from that 5-minute conversation. But I think we made that point. Okay, so now she's having some interaction with this jail mental health official, and Donna gets nervous. She doesn't want to tell this mental health official about her medications. She doesn't want to tell this official about medications because she could not see the official's face and wanted to verify that they were in fact a healthcare professional. Now, why would Donna really care? You're in jail. Like, are you afraid about HIPAA? Like, what? This official's asking you about your medications and you're not going to tell her? What do you have to lose? Maybe you'll get your medications. Maybe you'll get out of the solitary unit. Why would you play tough now? Not exactly clear what was really going on here. But to continue, she says that Donna made her concern known, and the official told Donna that Donna is a fancy white lady who murdered her son and now thinks she has rights. So is that very nice to say? No, it's not very nice to say. Is it actually true it's actually not true. Of course, Donna has certain rights in jail. She doesn't have all her rights, but she has certain rights in jail. She has the right to her First Amendment right? She has a right to practice religion. She has a right to speech. She has her Sixth Amendment right. She has 14th Amendment right. She has plenty of rights in jail. She doesn't have a Second Amendment right. There are certain rights that are taken away. Sure, certain rights are taken away. But was the official correct for saying that you have no rights here? No, she wasn't correct. Was it nice to say? No, it probably wasn't nice to say either. Do we care that much? Well, the attorney wants the judge to care about that she's not being treated nicely. Okay, let's move on. Well, then she says, well, since that interaction, some of the jail staff have treated Donna with cruelty. So it seems like since that interaction, maybe this jail official went and told other guards that, oh, don't be nice to Donna, treat her with cruelty. And that's the suggestion, that's the inference that they're trying to make here. That since that interaction, some of the jail staff have treated Donna with cruelty. She is sometimes denied her necessary blood pressure medication. Now we finally get to something that actually is significant. She is sometimes denied her necessary blood pressure medication. That actually may play a significant role under the law, which we'll see soon. And she is prevented from showering for days at a time. Okay, that's not so nice either that she's prevented from showering. Is that criminal? Is that actionable? Maybe not. And then she says in that 15 days that Donna's been there, she's only able to speak to her husband. She was not able to talk to her counsel at all. That's what they say. So there's no conversations at all between her attorney, Donna's attorney, and Donna. Now, at one point, a psychiatrist working at the jail told Donna that she does not belong in the solitary unit, and another jail official also told her so. So now you have two jail officials that have seemed to have told Donna that she doesn't really belong in the solitary unit, and really she should be in the general population. Despite repeated attempts to call the jail, set up video visitation, and or set up in-person visitation, undersigned counsel has been unable to communicate with Donna since her transport to Leon County Jail. Now again, like I said in the beginning, I think it would have been helpful to specify, I tried to call on this date, I had this date, I had this conversation, I spoke to this person, but none of that, she does not go into detail. So that essentially are the factual allegations, and we spoke about not having an affidavit to that effect. And, if she's not able to actually see Donna, then it's understandable, and the judge can still take these factual allegations with a certain level of seriousness, because there's just no way possible for her to get an affidavit. Now, again, the question really begs how she found out all this information if she had no contact. That question, I think, still remains. Okay, but now let's talk about what are the legal bases here. Was there any legal problems here? Well, the first legal problem is that there's a Sixth Amendment violation. What's the Sixth Amendment guarantee? The Sixth Amendment guarantees the right to effective assistance of counsel. So no matter how bad you are, no matter how terrible it is, no matter what you're accused of, what crime you're accused of committing, you are guaranteed the right to effective assistance of counsel. And therefore, if you're not able to communicate with your lawyer at all to prepare your defense, then obviously you're being denied the effective assistance of counsel. So that's pretty straightforward, that there seems to be a violation. Now, how often can they get to meet? What would be considered effective assistance of counsel? So they go into detail here. Donna's attorney goes into detail here saying, look, there is so much to go through. There's tons of documents. There's years and years of investigation that went into this crime. And therefore, we need every available minute to go through this stuff together. It's not enough to meet with us once every 15 days. We've got to be much more in contact to prepare this case for trial, which is a decent point. So she's saying, number one, there's a Sixth Amendment violation here that she's not allowed effective assistance of counsel. Okay. Number two, the second part here is where we get into the Eighth Amendment. The Eighth Amendment's a little more interesting. The Eighth Amendment we've all heard of also. The Eighth Amendment provides the following. Excessive bail shall not be required, nor excessive fines imposed, which is not our topic today, nor cruel and unusual punishments inflicted. You are not allowed, and from the government's perspective as a government, the government's not allowed to inflict cruel and unusual punishments. Now, that seems like a very broad category. What exactly fits under cruel? What exactly fits as unusual? And what is cruel and unusual? Do you need both? So this is all discussed in the case law, but I'm going to make it a little simple. And so we've got, basically, it goes into two categories, cruel and unusual punishment. One category is unnecessary and wanton infliction of pain. Number two, that's one category. unnecessary and wanton infliction. So that would look like this. What's necessary infliction of pain? How do you have necessary infliction of pain is, for example, let's say there is a jail riot and there's these prisoners that are fighting with each other. In order to break it up, the guards have to physically inflict pain on some of these prisoners to get them to stop. That is necessary. But unnecessary is if a prisoner is just sitting in his cell reading a book and a jail guard comes in there and starts beating the daylights out of him. That would be unnecessary and wanton infliction of pain. That would be a violation of an Eighth Amendment right. That would be cruel and unusual punishment. There's also a second category. The second category is if the following: a prison guard's deliberate indifference to a prisoner's serious illness or injury. If a prison guard shows deliberate indifference, he's deliberately indifferent. He's deliberately ignoring a person's serious illness or injury. So if you have a prisoner who's sitting there in his cell and he has a serious cut and he's bleeding, and the prisoner and the guard looks at him and just walks past, doesn't call for any help or anything. That's deliberate indifference to a serious injury. What about a serious illness? Well, a serious illness can be like diabetes, right? That's a serious illness. If it's under control, that's great. But if it's not under control, that's a serious injury. That can be life altering. Same thing, an argument can be made for blood pressure. Someone has high blood pressure, that can mean that the person can go and have a heart attack and they need their medication. If a prisoner is not allowed to have their blood pressure medication, then that could be deliberate indifference. It's deliberate indifference to a serious illness or a medical need. So that's where it comes back to, well, she's not allowed her blood pressure medication. That could be an Eighth Amendment violation. But here's where the law nerds come in. The Eighth Amendment claim can only be made on a person that's already convicted. If a person is already convicted and he's sitting in jail, then that person can be, that person has this Eighth Amendment right, and they can file suit against the jail or an individual for violating their Eighth Amendment rights. A person who has not been convicted yet, then actually there's no Eighth Amendment right, and that's also pretty clear in the case law. But there is protections under the 14th Amendment. So it's just a question of semantics, what you call it. Is this going to be an Eighth Amendment claim, or is this going to be a 14th Amendment claim? This is a 14th Amendment claim to due process. So this would be due process. You're obviously not allowed due process if you're being withheld medication that you need. That's a due process violation. So the only difference really is in this case where that the argument here would be that this is a 14th Amendment violation instead of an Eighth Amendment violation, the fact that they are withholding her blood pressure medication. Now again, we don't know for sure if this is true. This is if we assume that the factual allegations here that they're withholding her blood pressure medication is true. So that is their two legal arguments, two pretty decent legal arguments. And then what is their request for relief? So we said their first request is that they want them to go on house arrest. That's not happening. Or they want an independent psychological evaluation. So essentially that will get her out of the solitary unit, put her in the general population. And once she's there, she'll have a much more easier way to access her attorneys, to talk with her attorneys, and to prepare her defenses in this case. So the state does not oppose an independent psychological evaluation, which means that Donna's attorney contacted the state and asked Prosecutor Georgia Koppelman if she would agree to allow a psychological evaluation, independent psychological evaluation, and she agreed with that. So Georgia's okay with that. But the state obviously does oppose the letting her go to house arrest. So that's not going to happen. So most likely what's going to happen here is the judge will grant the independent psychological evaluation to get her out of this solitary unit, and then she'll be able to prepare her case much better for trial, but she is not most likely. I'd be very, very surprised if she gets out on house arrest. So that is what's going on with this motion. Very interesting. And we will, if you haven't yet, please subscribe, like the video so we can continue bringing this analysis to you. We will see you next time.